The question is that what is my paper? Clause 1.
But first of all,
I've got some amendments.
yes,
Just bear with me. We've got a number of amendments. Need to get the paperwork organised. Okay, we have a number of amendments in the name of Darian Fenton, which propose to change and amend the title of the bill. And I draw members' attention to standing orders, page 27. Preliminary clauses mean that the title clause and the commencement clause, and if applicable, the principal clause of the Act. So that's the title clause. The second issue here is that the amendments which are going to make changes have to be not an attempt to criticise the contents, but must be a serious or objective description of the bill rather than to simply try and relitigate issues and criticise the contents. Accordingly, the following amendments have been ruled out, and these are the injury prevention rehabilitation, reduced emphasis on rehabilitation costs, primary of cost reduction. Point of order, the Honourable Darren Hughes.
Sorry, Mr. Chairman, sorry to interrupt you. Just from the point of view of being helpful, could you just repeat the standing order that you were quoting? 27, I thought you said, which is...
No, page 22.
Oh, page...
I'm ahead of myself a little bit on that because this is going to come up later about...
Okay, so we've got this. So you're going to move, just so I'm clear, you're going to move through the different amendments to the amendments and the names of the different members, and
yes,
say which ones are not consistent with your view as Chairman.
The first one is that we're dealing with here is the amendments which attempt to criticise the contents of the bill.
Okay, and so
amendments have to be serious and in order, and if they are an attempt to relitigate issues or criticise the bill, the Speaker's rulings are that they are out of order.
And you're going to do that according to the member?
I'm going to go through them and explain that. Right. So the first one I've ruled out as just the in brackets reduced emphasis on rehabilitation and costs. Darian Fenton, I'm dealing with the ones on Darian Fenton at this stage. The amendment that seeks to insert the words primary of cost reduction, about experience ratings, alignment with commercial insurance practices, alignment with Australian practices, non-work and work account cost shifting, holiday pay exhausted before compensation paid, removal of cover for those who attempt suicide, reduction of cover for those with hearing impairments, removal of cover for those who attempt suicide, reduction of cover for those with hearing impairments, and then a move to the next amendment. Is that an amendment, this one here? Exhaust before compensation paid and non-work and work account cost shifting, ruled out. I now move to the amendment which is in order from Darian Fenton, and that is the amendment to amend the title of the bill to injury prevention, rehabilitation and compensation rebalancing between non-work and work accounts, Amendment Act 2010. That's in order. Yes. Call the Honourable Darren.
Point of order, Mr. Chairman. I accept your comments about the any titles or amendments which might be deemed to be taking away from the meaning of the bill's title as it currently stands. But on phrases such as alignment with Australian practices, we have a bill on the urgency motion relating to Trans-Tasman proceedings alignment. I don't mean to be flippant, or any reference to Australia by some New Zealanders would be considered offensive, but I don't think that I can say that this is a serious amendment, and it fits in with other bills that are on the urgency motion. It's hard to see how alignment with Australian practices would be somehow demeaning. Equally, sir, the removal of cover for those who attempt suicide, reduction of cover for those with hearing impairments are statements of fact. That's what the legislation does do, and it's not put. It doesn't say, if it said the terrible and unfair removal of cover for those with hearing impairments, I think that would be consistent with the inconsistent with the standing orders with regard to the way it would be putting a conjecture on the title. But simply to say reduction of cover for those with hearing impairments, when there are clauses that state exactly that in the bill proper, it's hard to see how that can be inconsistent. I mean, I'm not going against the other points you've made. We accept that those are out of order, the non-work and work account cost shifting, for example, we accept that. But on those three particular ones, alignment with Australian practices, I would have thought was a fairly neutral phrase, and the reduction of cover for those with hearing impairments is political differences aside, that's what the law does, and the minister's given speeches about that.
Well, in response to the member, I make 2 points. Firstly, the chair's decision is final and no correspondence is entered into. But in this case, I'm happy to accept a point of order. The issue here is the title is to describe the whole bill. This describes an aspect of the bill. It's not an attempt to describe the whole bill. It has to be an objective description of the bill, and where the amendment comes to pick out a point, it is to make a political point rather than to objectively describe the bill. So the bill has to be a wide generic term rather than contain specifics in it. And the point I make again is that amendments are ruled out where they attempt to highlight a point of difference in the debate or political differences over the bill. And on that basis, I've ruled it out. Point of order, the Honourable Darren Hughes.
Mr. Chairman, thank you for your ruling on that. That clears that aspect of it. But can you advise the committee how will we deal with these? Are all amendments to the amendment. Then the Minister himself, Dr. Smith, has SOP number 111, which is a significant SOP, which in itself renames the legislation. I think it renames it the Accident Compensation Bill, when clearly there are clauses and in the respective parts of the bill that cover injury prevention and rehabilitation. So the name that the Minister's amendment chooses highlights one aspect of what his law is doing, because it is about accident compensation. It will give weekly compensation to people who have had accidents, but it takes away the title of injury prevention and rehabilitation, which the Minister's law also covers. So how does it work when there's an opposition amendment that conjecture is put on, whereas the amendment itself that we're trying to amend does equally the same thing?
Well, with respect to the member's point, one of the amendments that you objected to was the alignment, for example, with Australian practices. That's not a particular aspect of compensation. That's a point of view that people in this House have or don't have. I come back to it as to be an objective description generally of the bill, not to relitigate particular points.
Let's get on with it.
Point of order, Pete Hodson.
Mr. Speaker, I've listened quite carefully to this, and of course it's your ruling, and I understand that you alone get to rule on it. That's clear to me. What I'm seeking to understand, however, is whether or not a title, an amendment to the title which, for example, were to say the accident compensation brackets, reduction of certain rights and services, close brackets, legislation, would be in order, on the grounds that although it points out something that the government may not wish to see point out from a political lens, it is nonetheless a broad description of the essence of the legislation that's in front of us. Would a title of that ilk be deemed to be within standing orders on the basis of your ruling?
Well, Speaker's ruling on page 112, 4, the amendment to the title of it must be a serious objective description of the bill rather than an attempt to criticise its contents. And the point the member has made is it is an attempt to criticise the contents. Whether the member believes it entirely to be true or not, it is, in the way the members described it, a negative and therefore a criticism of it.
Thanks very much.
Point of order, Pete Hodson.
It's a somewhere further. What then if the House were generally to agree that this is a reduction in certain services and certain rights? If the government held the view that that title was accurate, would that influence the chair? And how does the chair decide whether a reduction in certain services and rights is an accurate but nonetheless pejorative entitlement for a piece of legislation?
If the government was that opinion, they would have moved it.
If I might gently contest your view, that is not an answer to my question either. The question is, if an opposition moves something which is in essence accurate but is nonetheless pejorative, because oppositions do that